Hello everybody, so welcome back to my channel. Here I am outside the Supreme Court of the United Kingdom. So take a good look at the symbol here, the Omega, as in last letter of the Greek alphabet, because this is a court of cassation, as it were. It stops here, no further appeal. Though, all right, cases are occasionally referred to the European Court of Justice in Strasbourg, which is not a European Union court. And then you see that Tudor Rose of England, the white and red together, to show the Wars of the Roses ended, as the Yorkists and Lancastrians intermarried when Henry VII wed Elizabeth of York. And then you see the Thistle of Scotland, you see the Welsh daffodil, and for Ireland we see a not very convincing shamrock. This is Northern Ireland. And then over here, a bit of the Royal Coat of Arms, Judicial Committee of the Privy Council. So for some Commonwealth realms, this is the final court. Very few, some of the Caribbean countries. And then you see the Garter. It's not meant to be a belt. The Garter. On y soit qui mal y pense. Shame on him who thinks badly of it. Because I'm embarrassing myself now. Is it Edward I met a lady and her garter fell down, and this could be seen as a lascivious gesture. Well, that he picked it up and gave it back to her, and that's why he said on y soit qui mal y pense, as in it would shame the person who thinks that this is some sort of saucy act on his part. So it's so honourable what he did in returning her garter to her that he was going to found an order of chivalry, named after it. You know, the Order of the Garter. So yeah, this is a Supreme Court. It was the Guildhall for some time. Well, it was then it was part of really functioned as London County Council met here. When about 1889 they created Greater London. They took lots of boroughs out of the county of Middlesex, which was abolished. They took some land from Kent, some land from Surrey, and they created Greater London together with the cities of London and Westminster. This part of London is called Westminster because it's hard by Westminster Abbey. There, a Benedictine abbey till the 1530s. But despite there being no monks anymore, no abbey, it's still called Westminster Abbey, so it's for Anglicans. Anyway, so this building has served a number of functions down the years, I say. Then there was the Constitutional Reform Act of 2005, and that was part of a back-of-the-envelope plan. It was published in a press release which was chiefly concerned with the cabinet reshuffle when Tony Blair was Prime Minister. So there's a marvellous book by Charlie Banner, a QC. He wasn't a QC back then. He was still a law student. He co-authored with another budding young barrister. Off with their wigs, it's called. I mean, this rather haphazard attempt to reform the judicial system in the United Kingdom. Because prior to 2009, the House of Lords was the Supreme Court, as it were, or the Judicial Committee thereof. Because when I was reading about these judicial decisions in the House of Lords, as a schoolboy, I thought, what, do all the hereditary peers and the life peers vote on legal matters? No, they don't. It was only the law lords, about 12 of them. But they usually constitutional them sat, which was usually a group of 5 on a case. Anyway, so the Constitutional Reform Act of 2005, or CRA, said that the Supreme Court would be set up. The Supreme Court as such was established here in 2009. So Her Britannic Majesty came to open it. You can see footage of that on YouTube. And there was a speech by the Prime Minister at the time, Gordon Brown, another Labour man. So there are 12 judges in the Supreme Court. One of whom is the President, another who is the Deputy President. It's very rare that all 12 will hear a case. They usually have others. That's enough for the moment. Okay, goodbye.